I would like to request everyone to be seated. We will be beginning shortly. Okay. I would like to request our esteemed committee members to escort their lordships and Mr. Hariharan onto the stage, please. Okay. On behalf of the Center for Discourses on Criminal and Constitutional Jurisprudence, I welcome you all to our first discourse. The Center was conceived with the vision to provide a platform for continuous learning via lectures, discussions, and the like on various fundamental conceptions and principles that are vital for our legal system and its development, especially in the fields of criminal and constitutional law. This humble initiative, undertaken by a group of young lawyers, hopes that, in whatever little measure possible, the same might contribute to the onward march of jurisprudence via sowing the seeds of constructive thought. We have had a pleasant last-minute addition to our panel of eminent speakers. We are grateful to Dr. Arun Mohan, Senior Advocate, for gracing this occasion to share his wisdom with us. We would like to thank all of our speakers today for taking the time out of their busy schedules to be here with us. To inaugurate our first discourse, we shall begin with the lighting of the lamp. We request the speakers, along with our founders, Mr. Harsh Prabhakar and Mr. Akshay Bhandari, along with our committee member, Ms. Kaveri Birbal, to proceed with the same. Lighter. There it is. I told you they have to come quickly. Please. On behalf of the Centre, Mr. Rajat Badwa, Advocate, will now present a small token of our appreciation to His Lordship, the Honourable Justice Mridul. We now request Mr. Parmesh Bali to present a small gesture of our gratefulness to His Lordship, the Honourable Justice Bhambhani. Mr. Sumer Boparai will now present the same to Mr. Hariharan, Senior Advocate. And Mr. Aditya Mukherjee, Advocate, will present a small token to Dr. Arun Mohan, Senior Advocate, on behalf of the Centre. We are also grateful for the presence and blessings of esteemed former judges of the Delhi High Court, as well as for the presence of learned judicial officers. I will request Taira Katpalia, our committee member, to present a small token to Honourable Justice Veena Birbal. Committee member Vinayak Chittale will present a small token to retired Honourable Justice Sudarshan Kumar Misra. And committee member Pratham Sharma will present a small token to retired Honourable Mr. Justice Talwant Singh. We are also incredibly grateful for the presence of Shri Sanjeev Kumar Malhotra, Special Judge, Rouse Avenue Court, and Shri Devinder Kumar Garg, Joint Registrar, Judicial, Delhi High Court, for their presence. We will now begin with the lectures. Dr. Arun Mohan commenced his practice of law in the year 1970 and was conferred the rare distinction of being designated as a senior advocate at the very young age of 33 years, which is no ordinary feat. It is well known that he is regarded as an authority on civil laws, and his contribution towards shaping those laws cannot be adequately captured in any such introduction. However, few would know that he also shares an acute interest in criminal laws as well, and has assisted the courts as an amicus curiae on several seminal issues, including the Delhi High Court recently on evolving suitable strategies for detection of proclaimed offenders. Dr. Mohan will be speaking on the topic of presumption of innocence in operation as needs to be taught in our law schools.
Namaskar, honorable judges and my esteemed colleagues. I speak on a subject today which may, coming from me, because most have known me, be a little surprising. You distribute that. Distribute. It is presumption of innocence. after the 1935 Wilmington versus DPP case cited endlessly all over, what I failed to find during my various lectures at the law schools, that the fundamentals of presumption of innocence is not taught at the law schools. And today, my appeal is that the honorable judges with me today on the dais and others will persuade the law schools to teach some fundamentals of what are presumption of innocence in operation. I ask myself, what is a presumption? Presumption is nothing but an inference drawn from a known or established set of facts. Yet, presumption of innocence, all of us talk. Well, all my friends here will also presume to be innocent. But on what facts will they presume me to be innocent, and how will that presumption operate is what I miss out on. First, in this regard, I have distributed a two-side page, two-sheeter. Yeah. First side is how evidence has changed over the last 73 years. Last 50 years. 73 code, I take it. Now it's underway for a change again. In 1973, before a court, criminal court, at a trial, I think very few present today would have appeared at a criminal trial in 73. The only evidence was by and large oral and a little more. And today, how it has multiplied both its quantity and its types. That is what this histogram seeks. But then how does a court decide on a criminal trial? Finding of fact, guilty or not guilty. Fortunately, and I'll say very fortunately in India, after the Nanavati case, we do not have the jury system, who simply, as I examine in the West, in what words were the jury instructed? If there was error, acquit, mistrial. And the jury returns a finding, no reasons, guilty, not guilty. Each element of the offense charged is not analyzed by the jury as the judges, whether first instance or at a higher instance, appellate courts do in our country. In this regard, as you will see, the basic, in the back of this page, the basic principle of fact finding in criminal is there is a presumption of innocence. But how does it operate? This is what our law schools need to teach. I mean, I just put it with due respect to my law school. I'm grateful to Delhi Law Fact. But if 56 years ago I had been taught this, maybe I would have been slightly better off. And I could also say for others, presumption of innocence is no presumption in the true sense. It is an imaginary counterweight for the purposes of deciding a criminal case, rather appreciating the evidence. How does it operate? Now, placing myself first as a professor in a law school, and at the same time, placing myself as a first instance court, a judicial officer to decide a criminal case. First is, now I'll put it in a slightly melodrama way, so that, pardon me, that is not usual of address at places like this, but I'll need it. हाँ भाई पीपी साहब, क्या केस है? ये डेंजरस ड्राइविंग का है, डेंजरस ड्राइविंग का है. ओके, सो नाउ माय माइंड वर्क्स एज अ जुडिशियल ऑफिसर. What is the weight I will assign to the presumption of innocence for dangerous driving? भाई कोई मरा तो नहीं ना, कोई ज्यादा नुकसान नहीं हुआ. All right. So all we need is this little weight which goes to serve the presumption of innocence. And if the prosecution evidence remains here, sorry, acquit. But if the prosecution evidence overcomes the presumption of innocence, convict. I'm taking the lowest case. All of us at some times have done dangerous driving. I am no exception. So there is no presumption that I'm a safe driver. Now I take a completely the other extreme, murder case. Murder case. दिन दहाड़े 2 लोगों का खून हो गया. साहब, पीपी साहब कहते हैं गवाह आपके आगे है, मुलजिम को कड़ी से कड़ी सजा दीजिए. But how? First, what do I assign as a weight when there is a murder? This will not do as a weight, imaginary weight in my mind for the presumption of innocence. So, considering the offense charged, I'll pick up 1 kg. So here I place 1 kg as the presumption of innocence. So this is the weight I, as a judicial officer, have assigned to the presumption of innocence after going through the charge sheet and hearing the PP. Frame the charges. Trial begins. The trial continues, trial ends. And before the end, I will come to a point. This is the prosecution evidence. This is another prosecution evidence. This is another prosecution evidence. This is another prosecution evidence. But then, before I place it, I have to see ये पीतल है या सोना है, सच्चा है या झूठा है. So first part is determine what is the credibility of what is the prosecution evidence. Each item for each element of the offense charged. Some offenses have many elements, some have few. Second, अगर असली है तो कितने इसका वेट क्या है. ऑल राइट, इसका हमने 200 ग्राम वेट लिया तो ठीक है. अगर इसका वेट होता सिर्फ छोटा तो शायद ये काफ़ी नहीं था. It does not overcome and therefore it has to be a case of acquit. But before that there are 2 more stages in a criminal trial. The first is we have assigned the accused may give exculpatory evidence. Unfortunately, in our country, the police are selective in what they place before the court. In the charge sheet, the US rule of Brady versus Maryland is desperately needed in our country. And if there is exculpatory evidence being placed by the accused, once again, as a judicial officer, I decide genuineness first, weight later. And if there is any explanation, 313, then again it operates here. And then I wait. If the weight is this, it is convict. If the weight is just a little more, I just take it because we need beyond reasonable doubt. Sorry. Now, it is a little more, but it is not enough to be termed beyond reasonable doubt, and therefore it calls for acquittal. What is beyond reasonable doubt? to give an answer. Very often I have heard, very often I have read, beyond reasonable doubt is beyond reasonable doubt. Sometimes probability scales are used. 90 is a good one, 91 on a 100, or a 0.91 on a probability scale of 1. But why the difference from preponderance of probabilities? The answer is 3 items. Error of the judicial officer in giving it 1 kg weight. First error. Second error of the prosecution in adducing the evidence. The third is the error in my as a judicial officer appreciating the value or the credibility of any item of evidence, because it is not one, there are several. Direct, circumstantial, prior, contemporaneous, subsequent, they all form the link in the chain or the strands of a cable. That is criminal evidence before our courts. In that event, the law requires, and rightly, that this extra must be counted in favor of the accused. With this, I close what I have to say today, but I leave an appeal. I wish this part is begun to be taught in law colleges all over our country. Only then, my telling my colleagues, some my age, some senior, some less, is not the answer. We need it as an important curriculum in our law schools. There should be understanding by the students at that age when they can do inquisitive thinking and develop what is the presumption of innocence and its in operation. And then we have true criminal justice, that is minimal acquittal of the guilty and minimal conviction of an innocent. Thank you for listening to me. Namaskar.
We are grateful to Dr. Mohan for gracing us with his wisdom. Our next speaker is Mr. N. Hariharan, Senior Advocate. Mr. N. Hariharan completed his degree in law from the Faculty of Law at the University of Delhi. With no family background in law, he enrolled at the Delhi High Court, at the Delhi Bar, in 1987, and over the last 33 years has cemented his presence on the criminal side of the legal practice. For his contribution to the practice and development of criminal law, the Delhi High Court designated Mr. Hariharan as a senior advocate in 2013. As an advocate for civil liberties and individual rights, he represented clients in the Sura Hooch tragedy case, where over 200 people lost their lives due to the consumption of illicit liquor. As a specialist in criminal matters, he represented clients in the famous Shivani Bhatnagar case and in the Tehelka case in the early 2000s. He also appeared as special counsel for Salman Khan's prosecution in the Black Buck shooting case. Later in the decade, he defended clients in the cash for votes matter, the 2G spectrum allocation matter, the CWG matters, and the coal block allocation matters. Mr. Hariharan has also been appointed as amicus curiae by the Honorable High Court of Delhi for issues in criminal law, such as on the construction of separate and individual transactions under Section 219 of the Code of Criminal Procedure, the working of Sections 82 and 83 of the Code, and constructing the provisions of Section 258 of the Code of Criminal Procedure. Mr. Hariharan was also appointed as amicus for areas where codified law is nascent or fledgling, such as for the purpose of formulating guidelines for a standard operating procedure for transportation of mortal remains overseas for both Indian tourists and for Indians. Speedy and fair trial for the differently abled persons under the RPWD Act and the Code of Criminal Procedure. Rehabilitation of the forest cover in Delhi as a means for rehabilitation under criminal law. Mr. Hariharan will be speaking on Lex Certa, crystallizing the letter of law, trivial or imperative.
Honorable judges, Shri Arun Mohanji, my friends at the bar, my younger colleagues, my seniors, I have been given this unenviable position of speaking on a topic which I am trying to delve for the past 24 hours. There is uncertainty in my mind, and that uncertainty reflected in the order in which I have to address as well. I was supposed to come towards the end. I thought I would formulate something by then. So now that advantage is also lost. So bear with me. Speaking of Lex Certa, the word implies certainty. Could there be certainty in relation to legal principles and how to deal with it, how it came into place to begin with, a little bit of historical perspective, and then I will go into certain aspects which I felt would be relevant for this topic. Historically speaking, the late 18th centuries and the beginning of the 19th century was a time when Europe witnessed absolute monarchy. So there was absolutism as far as the rule was concerned, and interestingly, there was this divine right to rule which was accorded to kings and monarchs and queens. So which essentially meant that they governed by a principle, and that principle was that I will make you die and let you live. The choice was given to give life. That will be with the choice which was to be exercised by the monarch. From here, from this absolutist principle, this entire concept moved towards the welfare state. Now the welfare state, the concept reversed. And the concept now was, I will make you live and let you die. So we traveled from this entire distance of I will make you die and let you live to I will let you live and make you die, as I see it. When we say this, when the state makes you live, how does the state makes you live? That may be a question which will come to our mind. The state makes us live in many ways. It creates rules which sustains life. It creates laws which sustain life, welfare legislations, for instance, right? How food will be apportioned, maybe, by way of ration cards. Like that, there will be innumerable examples by the manner in which the state will make us live and ultimately let us die of old age, maybe, and reasons like that. So therefore, the shift was essentially from being able to rule, that is without giving a choice. You are ruling according to what you feel is right, and moving to an aspect where the state is governing, meaning whereby that the state is now coming into a welfare situation where essentially to govern, it needs to know, the constituents who are to be governed need to know how they will be governed. Now this ability of the individuals to know how they will be governed automatically moves towards what would be termed as a principle of certainty. You need to formulate laws. You need to know how you will be governed, right? So when we talk in those terms, the governance started being influenced by what one would term as the legality principle in criminal law. So it gave birth to something called the legality principle. And the legality principle in criminal law essentially comprised of 4 elements. One, where was the necessity for a legality principle, comes the first question. The first question was, in criminal law, as far as the legality principle is concerned, the legality principle was required, one, to protect individual interests in terms of life, liberty, and property. Even in today's times, we see that it is very relevant. It is relevant. It is always a question of an individual interest being protected in terms of life, liberty, and property. If you take the instance of situations which now governments do, which is quite akin to what governments used to do earlier, where today deprivation of property is used as a means of a penal consequence of something which you do. When you see the bulldozer acts being happening, you find buildings being bulldozed. You commit an offense, the consequence is that if you participate in that kind of an offense, probably the property which you own may get bulldozed. So it was against this kind of lawlessness or this kind of arbitrariness that essentially the legality principle started coming into play as far as modern welfare states were concerned. Now, when I talk about the legality principle, there were 2 essential aspects to it. One was in relation to individual interests, protection of the same, and the other comprised of adherence to 4 basic principles. Amongst the 4 basic principles we talk of in relation to adherence of the same comprises one which I am supposed to address on, and these 4 principles were, as could be seen, 2 principles which relate to prohibitions and 2 principles which do not relate to prohibitions. They relate essentially, if we see into it, they talk in terms of requirements. So the 2 principles which relate to requirements, they are termed as lex scripta, which was the first principle, and the second in relation to requirement was lex certa, in relation to which I am supposed to be addressing this topic. Now, lex certa essentially meant that the penalties which come along with offences need to be codified. So therefore, the law should be certain as far as lex certa is concerned. There should be codification, and lex scripta essentially meant the requirement, especially in relation to codification, the penalties to be codified was lex scripta, and lex certa was in relation to the requirement which implied that laws authorizing the kind and degree of punishment should be specific and definite. So these were the 2 requirements. So now what were the 2 prohibitions which came along with this? The 2 prohibitions saw that, one, no ex post facto laws would be applicable. That was the first requirement, the first prohibition which came along with this requirement. And the second prohibition which came with this was in relation to applying the law as an analogy, applying criminal law in an analogical form. Now I will speak in relation to that also, as to how law has to be strictly interpreted in criminal law without drawing on analogies. So this was the manner in which all modern welfare states were supposed to be governed in terms of the application of criminal law. And this is how the law of certainty started getting crystallized. Now the question that arises is that criminal law essentially, as we know it, is usually divided into substantive law and procedural law. The first element, that is the substantive law part, contains certain primary rules and norms that delineate actions which qualify as criminal offences. The criminal code discusses about the same. The penal code provides a situation where this kind of a scenario is contemplated. Interestingly, the criminal code also has, besides these primary rules, generally these primary rules are hidden within secondary rules. The primary rules being hidden under secondary rules, when I say this, as an example, I can give an example. For instance, whoever hacks into a computer system, say, unauthorizedly, can be punished for a maximum period of, say, 3 years and a fine of, say, 10,000. Though this norm is essentially and explicitly addressing the state, where it is attributing the legal power to a state to punish a person if specific conditions are satisfied. Now here, the specific conditions which are satisfied have been spelled out. This is, besides this is the norm which is in relation to the state. But how is the norm indirectly addressing the citizens? Indirectly it is addressing the citizens by delineating a prohibited action as punishable. It is saying that if you do this, there could be a punishment which will be entailed. So indirectly it is also spelling out for the citizen a norm that where the citizen can foresee what will happen in case he infringes a particular situation. Interestingly, outside the criminal code also, the criminal code meaning the penal code out here, which is the generalized law, statutory law also comes into place, where provisions are made in relation to offences. We have number of acts. The NDPS Act could be an example. Now in these kind of separate acts, here what happens is that as far as rules of punishment are concerned, they come as secondary rules which essentially come as an addendum in relation to the primary rules which are already formulated in the main act. They come in terms of enforceability. When we talk in that, for example, with the NDPS Act, I could give an example of section 22, for instance. Section 22 of the NDPS Act, for instance, punishes contravention in relation to psychotropic substances. Whoever is in contravention of this act or rule, made or the condition of license violated, will be punishable with so and so situation. The secondary norm in relation to this, which relates to the violation of this primary norm, we find in section 8. What does section 8 say? Section 8, prohibition of certain operations. No person shall produce, manufacture, possess, sell, transport, warehouse, use, consume, interstate or intrastate, or export from India any narcotic, drug or substance. So here we have a primary norm and a secondary norm which we find in relation to statutory legislations which are apart from the penal code. Now having said this, therefore one can say one thing, that substantive law essentially makes the conduct punishable. One, with what punishment? Conduct must be punishable. That conduct which is unlawful at least. This is one of the minimal requirements. And further, the relevant conduct must be defined in such a way, in a precise way, which the citizens are able to make out that they are liable for punishment. These are two considerations which go hand in glove. So what does lex certa signify in this context? Lex certa signifies in this context that one, there should be a reasonable and precise formulation of criminal offences to prevent over-inclusive criminalization. When I say over-inclusive criminalization, there will be definitions in criminal law which go beyond what the definition is in terms of interpreting the said law. I will give an example in relation to that. And the second element is, in relation to lex certa, that there should be protection against retroactive legislation being applied. Now this entails actions and omissions which can be punishable if they were criminalized when they were performed. So supposing there is an act which is not punishable today, but tomorrow there is a legislation which comes and renders it punishable, it would not make you liable in relation to the said offense. That is rule number one. This rule, of course, has been interpreted in many ways. There are other aspects also to it. For instance, there is an aspect in relation to retrospective operation where punishments in relation to an offense cannot be increased retrospectively. But in case those punishments are reduced, the law says that since it is beneficial and benevolent in nature, it will find an application as far as the accused is concerned in relation to the present scenario as well. So there is applicability there. Now, when we look into the Indian context, Article 21 of the Constitution deals with this element and this aspect, wherein the law categorically talks about punishment. It talks about the fact that you cannot be punished with retroactive legislation, with retroactive law. But interestingly, it does not invalidate retroactive law. It does not say that retroactive law is invalid. So therefore, it leaves within it a scope for judicial interpretation, where the judiciary, while interpreting retroactive law, could in situations come out with an interpretation that retroactivity in relation to the substantive offense when we are dealing with this particular situation may not be applicable, because the law is not invalid. The law has not been declared to be invalid, it is only the punishment part. So therefore, when it is not declared as invalid, that little space of discretion is still available. And it has been used depending on the manner and the circumstances. The example that which comes to my mind is in relation to the striking down of the provisions of 45, 1 and 2 as far as the PMLA provisions are concerned. When these were considered in the judgment, they were declared as unconstitutional and struck down. The state came up with an amendment. The challenge in relation to 45, 1 and 2 as far as PMLA was concerned at that time was twofold. One was in relation to a challenge that it was violative of Article 14 and 21. The other aspect in relation to that was that as far as the schedules were concerned, there were two schedules A and B at that point of time. In relation to schedules A and B, those schedules were found to be unconstitutional because the categorizations were not agreed upon by the Supreme Court when it examined it. What did the state do? The state, by way of an amendment, decided to do away with the schedules. So the subsequent judgment which came in Vijay Madan Lal Chaudhary, which is now the law of the land, gave credence to the fact that since the statutory basis of the same has been removed, therefore this law would be considered to be good law at the time when it was passed. So they were able to do this by that device. Of course, it is debatable and will be subject to more challenge and review. The review is still pending. That apart, but there are situations where retroactivity in terms of law, there is judicial discretion to interpret the same. Now, having said that, one of the fundamental situations which we come across in terms of law, because uncertainty and certainty are two things which pervade the entire concept of criminal law as we look at it. The first element is that whatever law is to be drafted in terms of penalty, it has to be drafted with precision. It has to be clear, cogent and precise in relation to the offense that it defines. A very interesting case came up in Netherlands in relation to this, which demonstrates that how criminal law functions not only in various jurisdictions, but where this also will illustrate how analogy was used to arrive to convict the person concerned. This case is also known as old style and smart metering case. It was a case of electricity theft. In Netherlands, there was a dentist, a Dutch dentist, who found that the electricity bills that he was getting was very heavy. So he decided that there is some way in which I must intervene So what he did in relation to this, he thought of using a knitting needle and placed it on the meter. In a way, he fiddled with the meter. And of course, he reaped the benefits of getting lower electricity bills for a considerable period of time. This came to the notice of the state during an inspection, and they slapped a case of theft against him. Now, when this case of theft came up before the Court of Appeal, a very interesting stance was taken by the dentist in his defense. The stance that he took was that electricity being intangible, it was not a good. It was not something which was substantive, it was not a good. So if it was not a good, there could be no theft in relation to the same. Now this example, when it was given, the Advocate General, who was also opposing the case, interestingly assented to this view. He also took the stance that since it is intangible, so therefore it was not a good in that physical form, so therefore there could be no theft. Now, how to go about this problem? What did the court do? The court was aware of the fact that as far as tangibleness is concerned, it would not be in a position to return a finding. So the court decided to look into the definition and interpreted what a good would mean. And the court went along to say that it had 4 attributes. One, the first attribute was that in relation to a good, that it had an independent existence. The second element was that there was transferability. There was the element of transferability as far as it was concerned. And the third aspect was that there was economic value to it. And the fourth was that there was appropriation. So it said that all these 4 parameters, if you look into it, it more or less satisfies the parameters of a good. So in a way, what the court did in this was that it said that, okay, when it satisfies all these 4 criteria, which are essentially the criteria which need to be satisfied when there is a tangible item, even if electricity is intangible, we say that there is theft of the same. Now this is something which you cannot do in criminal law. This drawing of an analogy is prevented in penal jurisdictions, reason being that if this kind of analogy is allowed, then the limits of an offense can never be defined. An interesting case came up before the Supreme Court also in 1960. And this case before the Supreme Court was termed as the Gunda case. It revolved around the definition of a Gunda. Then, in the state of Madhya Pradesh, as it was then called, it was called the Central Provinces and Berar at that point of time. They came out with a legislation wherein they said that as far as a Gunda is concerned, they defined a Gunda. And in that definition of a Gunda, they said that who would be a Gunda, according to them? A Gunda would be a person who was not only a hooligan, not only a rough or a vagabond, but it would also include any person who is dangerous to public peace and tranquility. So therefore, though you may not be a hooligan, though you may not be a rough, though you may not be a vagabond, but if you are a person who is dangerous to public peace and tranquility, which could be any one of us, it was enough to qualify within the definition of a Gunda. So it was this inclusive part. The definition was couched with an inclusive way. This inclusiveness which was brought about in the definition was something which the Supreme Court said that you cannot do it in this fashion. If then we accept this, it would amount to a common man being subject to this vagary and uncertainty, and that is not what the law is intending to do. So I am trying to give you certain examples to illustrate that how this law of certificate of being certain operates. Of course, there can be nothing. Certainty is just a concept which we all try to attain. It is not something which is attainable, but that is what we strive to. Way back when science saw its development over the period of time, I remember something which I read in law school, which I read in school, called the Heisenberg's principle of uncertainty. Now, the Heisenberg's principle of uncertainty says that there is nothing certain in life, in the sense that you cannot determine the position. For instance, from here, I can see that the learned judges are sitting here, but I cannot say that with certainty that they are actually sitting here to practically say what Heisenberg said, because the moment their speed and momentum of an object here, this and the ability to estimate the distance, these two things will, one parameter will always influence the other. So therefore, you cannot estimate with certainty at any point of time whether one object is at a particular place or not. Broadly speaking, this was the uncertainty principle which I read in school. So that uncertainty principle applies to law as well. Because here, what happens is, to give certainty to law, there is legislation which comes in. Now that legislation needs interpretation. When it comes up before the court, it is subjected to interpretation. In common law jurisdictions in England and in US, for instance in US, it is judge-made law which complements with statute. So it does in our country as well. This judge-made law, when it complements with statute, which means that there can be no certainty, because interpretation gives rise to various aspects as far as the element of interpreting what actually the legislature said, uncertainty sets in. Now, having said that, I will quickly conclude in relation to one other aspect, and that, as we normally know in criminal law, when we talk about the elements of an offense, now that I have said that it has to be precisely defined. Now, when we talk in terms of the elements of an offense, we say generally that it needs to comprise of two aspects. One is the actus reus and the other is the mens rea. Now, the actus reus is an action, and this action which we talk of, when we talk in terms of that action, we talk in terms of the law of evidence. An action takes place, it is a question of fact. When it comes to a question of fact, come back to what Dr. Arun Mohan said, then it has to be determined by a court of law as to whether that fact existed or did not exist. Mens rea is the mental state, an intention to perform an act, and that act should be within the scope of being a criminal offense, that state of mind. Apart from that, over a period of time, two more elements get added. And these two elements which get added over a period of time, which I feel, one is wrongfulness. Stated in terms of criminal procedure, this wrongfulness could also be regarded as a defense of justification. I may have a justification for doing something. That also gets factored in relation to the offense. And the third element will be the element of an excuse, which essentially goes to the construction of culpability. Now let us examine this in a practical point of view. We begin with this, that the conduct that is being charged must be proven beyond reasonable doubt, something which Dr. Arun Mohan also adverted to. When we talk about this proposition, there it pertains to a certain element of certainty. Beyond reasonable doubt is the element of certainty here. Now, when we talk of rules and laws of evidence, what does the defense say? The defense says, I did not do this. There is a charge, and in relation to the charge, when it is framed, the accused takes a defense saying that I did not do this. The consequence is that a trial will follow. Now, post the trial, it will be the proof and certainty of the proof of the facts which will determine whether the person concerned will be acquitted or convicted. So here again comes the aspect of certainty. Now I come to the second example. The proven conduct must qualify as a criminal offense. This is a legality principle. Now here I am giving you an example. The example is that I am found in the possession of poppy seeds and tried under the NDPS Act. Not in the possession of poppy leaves or other aspects, but in the possession of poppy seeds. My defense is that though proven, this is not a criminal offense. The reason being that the NDPS Act talks about the fact that possession of poppy seeds is not an offense. So this aspect will essentially bring to fore the fact that the proven conduct must qualify as a criminal offense. Otherwise, if it is not a criminal offense, then in that situation, you have no option but to acquit the person, and therefore, again, moving towards the certainty principle. The third element would be justification. Now, interestingly, whether I have a justification, this is a defense which I can take. The question is that I am being tried for killing a person intentionally. I fulfill all the conditions of section 300, but nonetheless I am not punishable because I am justifying the act by grave and sudden provocation, or I am taking the ground of self-defense. So therefore, I remember the Bible saying, there is a saying in the Bible, one of the commandments which say, thou shalt not kill. And that's it. But this thou shalt not kill produces so much of uncertainty within it. Whom you should not kill. Whether there is a justification in killing somebody. Who shall not kill? Can the state kill? So there are all these questions which arise with that. So there is no certainty in saying that thou shalt not kill, though it has been laid down as a law. Now going a little further, the fourth element is that though I was culpable, but that culpability will have to have that certainty that the accused did not have any excuse. He should not have an excuse for that culpability. The example for this is from the Prevention of Corruption Act, Section 8. Somebody gives a bribe to someone, right? It qualifies this giving of a bribe with a proviso which says that this section will not apply where a person is compelled to give such undue advantage. It is qualified with this. So therefore, law with certainty will have to prove that this aspect was not there. It is only then that a conviction can result. So these are the four aspects which I thought I would produce in terms of practicalities when we deal with offences in criminal law. And I will conclude with this, that certainty, yes, is certainly not certain. Though it is an ideal which needs to be achieved, but it is not certain. I myself was very uncertain when I was dealing with this and trying to understand as to how to gather an address in relation to that. Thank you very much for all your attentions.
Thank you, sir, for that illuminating lecture. Our next speaker is Justice Bhambhani. Justice Bhambhani joined the bar in the year 1992. As a lawyer, his area of practice spanned across multiple jurisdictions, including criminal law, which was particularly close to his heart. While in practice, he was appointed as an arguing counsel on the criminal panel of the Delhi High Court Legal Services Committee. In the year 2014, he was also appointed as a nominated member of the Statutory Committee of the Delhi High Court Legal Services Committee. He was also a member of the Monitoring Committee of Legal Aid Lawyers and devoted his valuable services even on the administrative side of the committee to make it more robust in its salutary mission for securing effective legal representation for the indigent and the marginalized. It may be noteworthy to highlight that as a practicing lawyer, Justice Bhambhani had the occasion to appear on behalf of the juvenile accused in the Nirbhaya case before the Honorable Supreme Court while resisting the prayer for the juvenile to be tried as an adult. The Supreme Court favorably concluded by rejecting the prayer and also observed that if the legislature, in its wisdom, had adopted the age of 18 years as the dividing line between juveniles and adults, then such a decision was constitutionally permissible. Justice Bhambhani was designated a senior advocate in the year 2014. He was appointed as a judge of the Honorable Delhi High Court on 22nd October 2018. As a judge, Justice Bhambhani has adumbrated upon various aspects of criminal law and delivered judgments which are every day cited by judges and advocates alike. In Dharmender Singh versus State, His Lordship observed that the presumption under Section 29 of the POCSO Act ought not to arise at the pre-charge stage before the commencement of trial. In Sanjay Malik versus State, His Lordship held on the principle that consenting to a situation is distinct from consenting to sexual liaison, and that consent can be vitiated by circumstances that erode the freedom of choice. In Ashish Mittal versus Serious Fraud Investigation Office, in the context of offences punishable under Section 447 of the Companies Act 2013, which is saddled with the twin conditions restricting the grant of bail, Justice Bhambhani underscored that it is imperative for the prosecutor to put forth a reasoned opposition to grant of bail and creatively developed law in this novel direction. In Suman Chadha versus Serious Fraud Investigation Office, His Lordship held on twin conditions not being applicable if an accused is summoned without having been arrested or remanded prior to that date. His Lordship will be speaking on fair trial, fairy tale, narrative, or more.
Chief Justice Designate my Lord Justice Siddharth Mridul. Dr. Arun Mohan, Mr. Hariharan, Senior Counsel, Honorable former judges of the High Court, senior advocates, other members of the legal fraternity, ladies and gentlemen. Let's begin by asking ourselves certain questions. Faced with the mighty state, perhaps forsaken by society, perhaps also forsaken by family and friends, who does an accused person depend on? Likely cast away in prison, reduced to a Kaidi number, all his personal possessions, all his resources, all connections taken away. Who does an accused depend on? Often resourceless against the power, of the mighty state, what is his residual expectation from the society, from the system, which has put him in that position? I would say the answer is fairness in the treatment that is meted out to him at that point in his life. Article 21 of our Constitution is very pithy, it's very profound, few in words but very deep in meaning. It says that no person shall be deprived of his life or personal liberty except according to procedure established by law. But are these words purely conceptual? Are they pedantic? Are they only theoretical? How do they really pan out in real life? Into what facets can this concept of fairness of treatment in the criminal process be passed out? What is it that makes fairness in the trial process come alive? What is it that we must do to avoid this situation where the accused who are incarcerated say that it was 800 years ago that they gave us the right to justice and to fair trial, and here we are hanging in prison? Andrew Ashworth, a QC, in a very erudite piece written for the Hamlin Lectures, explores procedural fairness and lists out the following 10 intrinsic aspects of a fair trial: right to be presumed innocent, privilege against self-incrimination, right of silence, the right to legal aid and assistance, the right to be brought promptly before a court, right to be released pending trial, right to disclosure of evidence, right to confront witnesses, right to be tried on evidence not obtained by violation of fundamental rights, and right not to be placed in double jeopardy. Now, of course, these are very elaborate things and we have to reduce them. But what do we say? Let's go back to the previous slide. What would you say when the judge asks guilty or not guilty? Not so what if I did it? So let us just stick to a few of the intrinsic aspects of fair trial, and let's focus only on a few of them, which I think are more relevant and pertinent and topical, at least in our jurisdiction today. And the three that I've chosen are right to be presumed innocent, specifically influence of the media on trials. The second one that I would just allude to is right to legal aid and assistance, and more particularly the quality and the effectiveness of the legal aid that we provide. The third is the right to disclosure of evidence, and in particular something that Dr. Mohan also alluded to, the suppression of exculpatory evidence, and also briefly to the effects of artificial intelligence on issues of disclosure of evidence. Now, the right to be presumed innocent has a certain problem because penal provisions are highly susceptible to misuse, particularly because even the charging of a person with an offense can create a cloud over his persona. Though as theoreticians and as professionals we are taught the difference between an accused and a convict, but mere allegation, and we are also taught that mere allegation is not proof of itself, but in practice the narrative is quite different. Charging a person with an offense is it in and of itself stigmatizing. Even lawyers who defend persons accused of heinous offenses tend to acquire a certain reputation in a general sense of the word. And I am not looking at Mr. Hariharan at all at this point in time. As thinking members of society, not only because we are legal professionals, it is necessary for us not only to ingrain within ourselves, but to also control the narrative which prevails in society generally, by which a person who is merely charged with an offense is almost immediately shunned by society. Arguably, this exclusion from society in itself vitiates the atmosphere that is required for a fair trial. What aggravates this is the inescapable fact that criminal trials, especially in our jurisdictions, take inordinately long, and until a person is acquitted, if that, he continues to suffer this stigmatization for many, many years. The simple fact of a person being charged with an offense today will inevitably result with his closest friends, even family members, distancing themselves from him. If there is any evidence to be led through such people, if there is any statement to be recorded from a family member or a friend, the chances are people would distance themselves because they don't want to be roped in, as it were. The society faces this as a real problem, but the consequences are borne by the accused. You only have to pick up the newspaper or scroll through your social media feed to know how today's media, and sometimes even just individual busybodies, they jump into the fray and have a field day the moment they find that a person has been implicated in an offense. And the better placed you are in society, or you imagine you are better placed in society, the worse it is for you. Now, one very important facet of this is that investigating agencies and judges are not immune to such media pressure. The pressure of the narrative built around a case digresses and changes the course with which in which matters or cases can go. In England, there was a time when Lord Denning had held in a case which came before him in the Court of Appeals, Attorney General versus BBC. This was a 1981 matter, where he took the view that professionally trained judges are not easily influenced by publications. This was, of course, before the times of social media and electronic media. But even then, when the matter went up to the House of Lords, Lord Dilhorn disagreed with Lord Denning, and his words are prescient. It is sometimes asserted that no judge will be influenced in his judgment by anything said by the media, and consequently that the need to prevent publication of matter prejudicial to the hearing of a case only exists when the decision rests with laymen. This claim to judicial superiority over human frailty is one that I find some difficulty in accepting. Every holder of judicial office does his utmost not to let his mind be affected by what he has seen or heard or read outside the court, and he will not knowingly let himself be influenced in any way by the media. Not, in my view, will any layman experienced in the discharge of judicial duties. Nevertheless, he said, it should, I think, be recognized that the man may not be able to put that which he has seen, heard, or read entirely out of his mind, and that he may be subconsciously affected by it. The same was a view taken by Justice Cardozo in a piece which he called Nature of Judicial Process. And I would like to read these words because they are prescient. Deep below consciousness are other forces, he said, the likes and dislikes, the predilections and the prejudices, the complex instincts and emotions and habits and convictions which make the man, whether he be litigant or judge. There has been a certain lack of candor in much of the discussions of the theme, or rather perhaps in the refusal to discuss it, as if judges must lose respect and confidence by the reminder that they are subject to human limitations. Nonetheless, if there is anything of reality in my analysis of the judicial process, they do not stand aloof on these chill and distant heights. The great tides and currents which engulf the rest of men do not turn aside in their course and pass the judges by. So then, we must always remind ourselves and be conscious that as judges, as counsel, as people otherwise engaged in the criminal justice system, we are all influenced by what subliminally, if only subliminally, by what we hear, what we read, and that influences our thinking. Now, this principle, the precept that Lord Dilhorn referred to, was echoed by our own Supreme Court in a 1969 matter in Re PC Sen, where the Supreme Court said, but our courts which administer both law and equity, assuming that a judge holding a trial is not likely to be influenced by comments in newspapers or by other media of mass communication, may be ruled out, though it would be difficult to be dogmatic on that matter also. The court is entitled and is indeed bound to consider, especially in a country where personal conduct is focus on these words, where personal conduct is largely influenced by opinion of the members of the caste, community, occupation, profession to which he belongs, whether comments holding up a party to public ridicule or which prejudices society against him may not dissuade him from prosecuting his proceeding or compel him to compromise it on terms unfavorable to him. That is a real danger which must be guarded against. The court is not in initiating proceedings for contempt for abusing a party to a litigation merely concerned with the impression on the judge's mind, even on the mind of the witnesses. For a litigant, it is also concerned with the probable effect on the conduct of the litigant and persons having similar claims. Enunciating, therefore, the truism that at the end of the day, judges are also human beings, that they would not lose respect by admitting to be so, and therefore, those who man the judging process must be protected from the pernicious influences of external forces, which in the present context, in large measure, is the omnipresent media. Now, I would extend that to a judge sitting in trial throughout the trial process. How, however, should we control or prevent this pernicious effect? How do we do it? How do we ensure that this does not happen? That the difference between a newsreader reading the headlines and a judge doing the same is maintained. Now, the answer, one possible method has been suggested by the Supreme Court in a Constitution Bench decision in Sahara India Real Estate versus Securities and Exchange Board of India, where the bench suggested the possibility of passing of postponement orders. Let us see what it says. Given that the postponement orders curtail the freedom of expression of third parties, such orders have to be passed only in cases. So, the theme here was that the leakage of a letter of settlement between SEBI and Sahara found its way to the media. An application came saying that the leakage of that letter is influencing the proceedings and it is in fact interfering in our settlement. A 5-judge constitution bench looked at law from across the globe and said that there is a way out, there is a possibility of passing postponement orders. However, they have to be rare and they have to be passed in only very few cases in these words. Given that the postponement orders curtail the freedom of expression of third parties, such orders have to be passed only in cases in which there is a real and substantial risk of prejudice to fairness of the trial or to the proper administration of justice, which in the words of Cardozo is the end and the purpose of all laws. However, such orders of postponement should be ordered for a limited duration without disturbing the content of the publication. They should be passed only when necessary to prevent real and substantial risk to the fairness of the trial court proceedings. If reasonable alternative methods or measures such as change of venue, postponement of trial will not prevent the said risk, when the salutary effect of such orders outweighs the deleterious effects to the free expression of those affected by prior restraint, in our view, keeping the above parameters, if the High Court or the Supreme Court pass postponement orders under their inherent jurisdictions, such orders would fall within reasonable restrictions under 19(2). So, apart from self-regulation, apart from media exercising self-restraint, in an appropriate case where there is demonstrable real risk of interference in the course of justice, in the process of fair trial, there is power available to the High Court and the Supreme Court in exercise of their inherent jurisdictions to pass postponement orders. The second aspect of those 10 aspects that Andrew Ashworth refers to is the right to legal aid and assistance. Now, legal aid, it takes no cogitation to say, is a crucial element of the right to a fair trial, because the system is abstruse, it has its own obscurities, it has its own specialities, and we are all exposed from time to time to a litigant arguing a matter in person. only 2 out of 10 litigants really help their own cause, if I may say so. That has been my experience, because mostly they argue against themselves. They argue as if they are not in a court of law, but standing before Jahangir or someone like that. Now, there are 2 clear stages at which this legal aid and assistance is required. First, of course, is the stage of investigation itself, and then, of course, is the stage of trial. Now, picture this. A person is called in for questioning by the police. He is not yet an accused. His name is not in the FIR. But he is faced with this hostile questioning environment in a police station, surrounded by police officers. He is obviously exposed, and he is obviously vulnerable psychologically, apart from being at physical threat. Now, should he not be entitled to legal aid at that point in time? He may even make a false statement only to secure his release at that point. He may even confess. What would become then of his right to silence? Now, the state's perspective obviously is that a lawyer's presence would obstruct the questioning. The lawyer may prompt his client and so that he doesn't answer the questions. But he doesn't answer the question to what? He doesn't confess. Is that the question you want him to answer? I have often encountered this in my tenure on the criminal bench. Somebody is granted interim protection in an anticipatory bail, and the IO comes back 9 times out of 10 in the status report, they will say that he is not cooperating. And I am at pains to ask, I have asked this very often, what is cooperation? What is he not doing? He will not tell us what he did with that cell phone which he was carrying at the time of the offense. To which I would ask, first of all, you are assuming that he was carrying a cell phone at the time of the offense. And in any case, the counsel on the other side, the defense counsel will say that he sold that phone, he's changed his phone, that was 5 years ago. He doesn't know what happened to that phone. No, he is not disclosing where that phone is hidden. So this dividing line between cooperation and confession needs to be drawn. I have initiated this in some of my matters. I have not had the occasion to close that question at our level. But this is a very important thing that happens, and it happens all the time. Now, we have certain international covenants to which we are signatory, which oblige the state to ensure legal aid. Article 14 of the ICCPR obliges states to ensure the right to legal assistance in criminal cases free of cost if the person does not have sufficient means. General Comment 32 of the Human Rights Council says that the assigned counsel must be able to communicate with the accused in conditions to follow confidentiality, ensuring privacy and access. I will dilate on those presently. How has the legal aid system evolved in our own country? Let's take a quick look at that. We could begin with Tara Singh versus State, a 1951 view of the Supreme Court, where the accused was a patricide. He had killed his own father. And this is what the Supreme Court had to say. I think it was Justice Vivian Bose. I need hardly say that the right conferred by 341 does not extend to a right in an accused person, extend to a right in an accused person to be provided with a lawyer by the state or by the police or by the magistrate. That is a privilege given to him, and it is his duty to ask for a lawyer if he wants to engage one, and to engage one himself or get his relations to engage one for him. The only duty cast on the magistrate is to afford him the necessary opportunity. So this was the beginning of the view on legal aid in 1951. Then in 1951, in another judgment in Janardhan Reddy, the Supreme Court says the proper view seems to us to be that it cannot be laid down as a rule of law that in every capital case where the accused is unrepresented, the trial should be held to be vitiated. and that a court of appeal or revision is not powerless to interfere if it is found that the accused was so handicapped for want of legal aid that the proceedings against him may be said to amount to negative a fair trial. This was where it all began. Then in 1993 came a very detailed report on the legal aid mechanism by the venerated Justice V.R. Krishna Iyer, where he referred to the need and the mandatory need for pre-litigation and post-litigation legal aid. Then came Article 39A, which was incorporated as a directive principle in 1976 in the Constitution. And let's take a quick look at the most important provisions of our legal framework which refer to legal aid. Article 22(1). No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall he be denied the right to consult and be defended by a legal practitioner of his choice. 39A. The state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way ensure that opportunities for securing justice are not denied. Then comes 304 of the CRPC, which you may look at. The court shall assign a pleader for his defense at the expense of the state. So legal aid evolved further by incorporation of these provisions. Then came the Legal Services Authorities Act in 1987, subsequently amended in 94 and 2002, which provides today a detailed framework for legal aid. The view then changed, and in 1979, in Husainara Khatun 4, the Supreme Court said this: this is a constitutional right of every accused person, they're talking of legal aid, who is unable to engage a lawyer and secure legal services on account of reasons such as poverty, indigence, incommunicado situation, and the state is under a mandate to provide a lawyer to an accused person in the circumstances of the case and the need of justice so require, provided of course the accused does not object to the provision of such lawyer. In Khatri 2, around the same time, the court had this to say: moreover, this constitutional obligation to provide free legal aid services to an indigent does not arise only when the trial commences, but also attaches when the accused is for the first time produced before the magistrate. Then the part highlighted at the foot of the page: the state is under a constitutional obligation to provide free legal services to an indigent accused, and not only at the stage of trial, but also at the stage when he is first produced. Thus evolved the legal aid mandate in our framework, legal framework, coming now to a point where in 2012, in the case involving a person who was unarguably public enemy number one, Ajmal Kasab, this is what the court said. It's a very long quotation, I'll read the highlighted parts. Right to access to legal aid to consult and be defended by a legal practitioner arises when a person is arrested and is first produced before a magistrate. We accordingly direct, so it's the duty and obligation of the magistrate, and we accordingly direct all magistrates in the country to faithfully discharge the aforesaid duty and obligation. Failure to fully discharge the duty would amount to dereliction in duty, would make the concerned magistrate liable to departmental proceedings. Not to be construed as sanctioning or permitting the presence of a lawyer during police investigation, the role of a lawyer is mainly. That may be the case, but just see what they go on to say further. In para 477, even if the accused does not ask for a lawyer or he remains silent, it is the constitutional duty of the court to provide him with a lawyer, unless the accused voluntarily makes an informed decision and tells the court in clear and unambiguous words that he does not want the assistance of a lawyer and would rather defend himself personally. So therefore, as we speak now, the law in our country is that provision of legal aid, go to the next one, is now an opt-out option to be exercised by an accused. It is there for him, he has to opt out if he wants, and at the same time we have to be conscious that legal aid for the poor should not be poor legal aid, and a person should not be put in this situation where he says, I seek vindication, and the lawyer says, I seek $300 an hour. At this point, I'm looking at Mr. Hariharan. Now, is everything hunky-dory in our legal aid system? We, at least speaking for the state of Delhi, we have a very robust system, but is everything in order? I'm afraid not. There are certain aspects which I will presently allude to, which need closer scrutiny and which need work. And before that, let me say this. As a judge, I no longer think that it is the accused who needs legal aid. It is the justice system which needs legal aid. It is we as judges who find ourselves totally at a loss if there is no effective representation. As lawyers, when we hear this phrase coming from the bench that you have rendered able assistance, we say, all right, it's all right, he's just saying something. But I cannot stress enough the fact as to what difference it makes if you get good assistance from counsel versus if you are left on your own to figure out and decide a case as you want. So some of the aspects which I think where we are a little weak, which are areas of concern in the legal aid system, first is the lack of opportunity to choose a lawyer oneself. Now, I know this is not easy to implement. In our Delhi High Court Legal Services Committee and in the entire legal aid system in Delhi, you can apply if you qualify the threshold in terms of the income threshold, you are assigned a lawyer. If it doesn't work out with the lawyer, you are entitled to ask for a change of lawyer. But the opportunity to choose a lawyer oneself, one is really not available in real terms. And besides, how would it be available? Because if people start choosing the same lawyer, I'm looking at Mr. Hariharan once more, it's not possible to really choose a lawyer for oneself. But then that is also the case. That is also the case otherwise, because not everyone can hire a lawyer who he thinks he wants. The second is the lack of training, dedication and commitment on the part of legal aid lawyers. Now, training, there are certain modules introduced by NALSA, but training, I'm not aware of any training module that lawyers have to go through before they are inducted on the panel of DHCLSC. Dedication is another thing which is a little elusive because it's difficult to monitor, it's difficult to measure. It depends so much on the lawyer concerned, and so is commitment. The third, I would say, is the lack of rigorous professional involvement. Now, when one receives a private brief, the kind of badgering one gets from the client, the kind of time that is demanded from the lawyer. Unfortunately, people who are subject of legal aid lawyers, who are dependent on the legal aid system, are usually not in a position to demand that kind of professional involvement. This again, therefore, has to emanate from the counsel himself. There is always the issue of adequate remuneration for lawyers, which must be commensurate with the work required to be put in. Sometimes payment is only made upon final conclusion of the matter, which we know is elusive. Another very important aspect that I would want to highlight, and this partly from my personal experience as a legal aid lawyer, is the lack of confidence in the quality of service provided. Now, this manifests itself in various ways. I have had personal experience of being ushered into the stairwell of the court and being told, "Sir, ये आपके लिए हम लाए हैं," and a packet is sought to be handed over to you. The belief being that no one works for free for anyone else. So one is at pains then, one was at pains to tell them that, look, I do get paid for this. The legal aid pays me. So thank you, but no thank you. But they don't believe it. And there are times when you'll find that the trial is being conducted by a legal aid lawyer, but when it comes to an application for bail, they produce a private counsel, duly paid and engaged. And you wonder, are you subject of a legal aid of the legal aid system, or do you have the resources to engage counsel yourself? The fact is, they just don't believe that a legal aid lawyer will do the job that a private counsel will do. Now, this is something, this notion has to be debugged. And again, the answers are not easy to find, but these are issues which require to be highlighted. The third aspect which I had pointed out was the right to disclosure of evidence. Now, Dr. Arun Mohan has also very correctly referred to this. I started by highlighting the physical and the mental state of an accused when he's under investigation, and worse still, that gross imbalance between the resources of the police establishment and the imbalance and the lack of resources on the part of the accused. One of the most grave problems in this behalf is the non-availability of any resources to undertake defense investigation, if you please. Now, there is no system, there are no resources, it is impermissible, just as an IO will come and present a charge sheet, file a report under 173. There is no system for an accused to say that I have also undertaken certain investigation, can I place that? For that he will have to await defense evidence. But one thing which could take care of this but does not is the full disclosure of all the evidence collected during investigation, instead of, as Dr. Mohan also said, selective disclosure only of the inculpatory evidence. Section 207 of the CRPC addresses this issue. I won't take time to read it, but this everyone is aware of, that there is a whole stage for supplying to the accused copies of the police report and other documents. Then 208 also talks of the supply of copies of statements and documents in cases triable by sessions. Then there is 173, which also obliges the police officer to give such statements. However, the problem, as we all understand, is that the police normally only produce the evidence that they need to produce, and especially now with a lot of investigation happening in very complex commercial crimes and financial crimes, where the IOs raid offices, they pick up electronic records wholesale, they walk away with servers, they walk away with computer systems, they neither leave copies nor make clones, and out of those 10,000 emails that they walk away with, they will produce 5 emails and say, look, this shows that the man is guilty. Now, there has to be something that needs to be done about this.
There is a judgment now.
This has been addressed by the Supreme Court in a seminal decision where the draft rules on criminal practice 2021 have been framed. In this case called to issue certain guidelines regarding inadequacies and deficiencies. And draft rule 4 reads thus: Supply of documents under 173, 207, 208. Every accused shall be supplied with statements of witnesses recorded under 161, 164, and a list of documents, material objects, exhibits seized and relied upon by the investigating officer. The list of statements, documents, material objects, exhibits shall specify statements, documents, material objects, exhibits that are not relied upon by the investigating officer. In P. Punnuswamy, the Supreme Court goes a step further to say that even where the high courts have not framed rules, this list of documents has to be given. Now, this is a recent development. We have to see how it pans out, whether that list of evidence which they are not relying upon is actually does actually help in arming an accused in adducing defense evidence. Another very important aspect which I think is part of a fair trial, and it would be subsumed in this topic, is the role of a public prosecutor, which again I think requires attention. We have never paid enough heed, and we've never held our public prosecutors to that standard. But the fact is that the Supreme Court has opined, can we have the next one? Yes. In Shiv Kumar versus Hukum Chand, and this was in 1999, the court says a public prosecutor is not expected to show a thirst to reach the case in the conviction of the accused, somehow or the other, irrespective of the true facts involved in the case. The expected attitude of the public prosecutor while conducting prosecution must be couched in fairness, not only to the court and to the investigating agencies, but to the accused as well. If an accused is entitled to any legitimate benefit, the public prosecutor should not scuttle, conceal it. On the contrary, it is the duty of the PP to winch to the fore and make it available to the accused. Even if the defense counsel overlooked it, the public prosecutor has added responsibility to bring it to the notice of the court if it comes to his knowledge. Now, I hardly think that any of us have witnessed a prosecutor bringing to the fore exculpatory evidence to say that that this is what is weak about my case. This is why my charge sheet should be thrown out. In a very recent decision, I think this is Justice Bhatt's decision, Manoj versus State of Madhya Pradesh. Justice Bhatt says a public prosecutor appointed under 24 occupies a statutory office of high regard. Rather than a part of the investigating agency, they are instead an independent statutory authority who serve as officers to the court. The role of the PP is intrinsically dedicated to conducting a fair trial, not for the thirst to reach the case in conviction. Now, a reference at this point can also be made to Rule 16 of the Bar Council of India rules, which says, rules governing advocates so and so, an advocate appearing for the prosecution of a criminal trial shall so conduct the prosecution that it does not lead to conviction of the innocent, suppression of material capable of establishment of the innocence of the accused shall be scrupulously avoided. And here we have a prosecutor who produces his pet dog and says, who's a good witness? I would add to this to say that there is a moral core to the prosecutorial function which must be preserved. It is necessary to safeguard that same moral core, and prosecutors have to be imbued with that sense. Now, very quickly, I think I'm far exceeding my time. Can I finish in 5 minutes?
Time is uncertain.
The impact on fair trial, impact of artificial intelligence on fair trial. Now, this is of course an evolving field. The concept of predictive policing is gaining currency. The state of Jharkhand, you will be surprised to know, is perhaps the only state with some concrete plans to introduce predictive policing, and they are impelled to do so because of the Naxalism that they have faced in the past. This is the application of computer modeling to historical crime data and metadata to predict future criminal activity. So ultimately, what they do is that they preserve historical crime data. They apply algorithms to record data patterns, and with machine intelligence and artificial intelligence, the system identifies relationships amongst variables that may not immediately be apparent. Now, what happens with this? The purpose is to identify likely targets of persons, of places, in order to best use police resources. Please don't waste your time in policing the precincts of the High Court. Nothing is likely to happen here. Please move to place X. Put more feet on the ground there, because that is where something has happened in the past. These are the people who have been involved in the past. Please keep a tab. Now, this happens even otherwise. Secret informers, tips being received by police and all is something that we've always known. But how does AI change all this? The way it changes it is because it is inscrutable as a system. So an informer, a human being who is an informer, can only bring to the police a certain quantity of information. He can only remember so much. If there are 5 different informers and they are giving information, the police have to collate all this. Now, this all is taken over by the AI system. So this concept really affects section 165 of the CRPC, which is the provision which provides for warrantless search and stipulates that the IO is entitled to do so if he has reasonable grounds for believing. Let's just get a quick conspectus of this. State of Punjab versus Balbir Singh, which explains the reasonable grounds for believing. What does it mean? The other requirement is that the magistrate of the officer acting under 41 or 42 should have reason to believe that such an offence has been committed, and therefore an arrest or search was necessary as contemplated under these provisions. Come to the next highlighted portion. The expression reason to believe is not synonymous with subjective satisfaction of the officer. The belief must be held in good faith. It cannot be merely a pretense. The material on which the belief is grounded may be secret, may be obtained through intelligence, or occasionally may be conveyed orally by informants. Whether there was such reason to believe and whether the officer empowered acted in a bona fide manner depends upon the facts and circumstances and will have a bearing in the appreciation of evidence. Now replace this informant with an AI system, an animal none of us really understand as of today, and picture people being profiled, areas and colonies being profiled, and searches being conducted, and when they are asked that what was your reason to believe or the reasonable grounds to believe, he says, I was prompted by the AI system. Now, this is an evolving field. What exact prejudice will be caused is something which is yet to be seen, but especially because in our jurisdiction we don't have that concept of the fruit of the poisonous tree. So evidence collected is admissible regardless of how it is collected, so long as it is relevant. That, read with AI systems in operation, is an area we need to be very, very skeptical about. The other aspect is that with AI systems, the extended presumption of innocence. So if a person is discharged or acquitted, normally soon enough matters are forgotten, but the AI system will not forget. So therefore the person may continue to remain in the zone of suspicion long after he has been discharged or acquitted. An arrest would always remain part of the police records and may also figure into profiling of persons much later. The point basically being that if in any field, in any manner, we try to reduce justice to an algorithm, we have to be very conscious what the impact of that might be. Now, concluding, I would say that the question embedded in the topic fair trial, fairy tale, narrative or more, these are intended to be discourses. They are not lectures. The idea is to raise the level of debate. And to use a phrase which I commonly use, I like that phrase, is that the idea is not to tell you what to think. It is to tell you what to think about. And the idea is to raise the level of debate and to pose questions which in the course of our practice as lawyers and judges we must pay special attention to. And it is for us to then answer for ourselves whether fair trial is a reality in our system or is it merely a fairy tale or a narrative. Thank you all so much for bearing with me. I must thank my LRs who are very dedicated. There's Benjamin here. There's Varun. There's Shayoni and there's Preetraj, and also to other LRs who were earlier with me and have now left, Meghna and Avanti. So thank you all very much.
We are grateful for His Lordship's keen observations and inferences. Our next speaker is Honourable Mr. Justice Siddharth Mridul. His Lordship needs no introduction, as all of us know. He is one of the most energetic and charismatic judges of the Delhi High Court. Justice Mridul graduated in the year 1983 from Hindu College, University of Delhi, in BA Honours History, and went on to pursue his LLB in the year 1986 from Campus Law Centre, Faculty of Law, University of Delhi. Justice Mridul was enrolled with the Bar Council of Delhi on 24th July 1986 and practiced as an advocate on a variety of matters relating to writ and writ appellate jurisdictions, civil original and appellate jurisdictions, company jurisdiction, and criminal jurisdiction in the High Court of Delhi. His Lordship also practiced extensively in the High Court of Judicature at Bombay, the Karnataka High Court at Bangalore, the Rajasthan High Court at Jaipur, Income Tax Appellate Tribunal, Company Law Board, Appellate Authority for Industrial and Financial Reconstruction, Debt Recovery Tribunal, National and State Consumer Dispute Redress Commissions at Delhi. His Lordship was appointed as the Standing Counsel for Union of India in 2004 and as a Senior Panel Counsel for the Union of India in February 2006. Justice Mridul was designated as a Senior Advocate in May 2006. Justice Mridul holds the rare distinction of being one of the youngest elected members of the Bar Council of Delhi for 2 terms, that is 1992 to 1998 and 1998 to 2003, as a member of the Disciplinary Committee. His Lordship has also served as the Honorary Secretary to the Bar Council of Delhi from 1994 to 1997 and as the Vice Chairman from 1998 to 2003. His Lordship was appointed by the High Court of Delhi as a member in various committees to go into, inter alia, the issues of rehabilitation of children after the abolition of child labour, illegal construction in contravention of municipal bylaws, and he was also a member of the committee constituted to suggest, supervise, and implement measures for the efficient and hygienic functioning of the Safdarjung Hospital in Delhi. His Lordship was appointed as an additional judge of the High Court of Delhi with effect from 13th March 2008 and as a permanent judge on 26th May 2009. With more than 15 years at the bench, Justice Mridul has painstakingly adjudicated matters of all rosters, from being a name known to one and all on the criminal side to having rendered various judgments on the company side as well. Justice Mridul has always held the personal liberty of any human being to be a matter of highest priority, and on a lighter note, Anyone who has appeared in his court knows that habeas corpus matters will always take precedence above all else. His Lordship's division bench was also one of the first benches to take up the urgent hearing of matters regarding personal liberty during the COVID lockdown. From improving conditions in the detention centers to quashing unlawful detention orders, your Lordship has been a guiding force in all matters of criminal jurisdiction. If one begins to recall all such matters that have impacted the judicial landscape on the criminal side, it will be a lengthy list. But, to name a few, in H.P. Chaturvedi versus the Central Bureau of Investigation, Justice Mridul observed that there can be no justification for denial of bail to an accused only on the pretext that the offense in question belongs to a particular category of cases, and also held that bail cannot be withheld at pre-conviction stage as a means of expressing disapproval. In the landmark judgment delivered in JBT, Junior Basic Trained Teacher Scam, he upheld the trial court's decision convicting 55 public servants and dealt with several abstruse questions of law. This decision of Justice Mridul attained the imprimatur of the Supreme Court and illustrates the judiciary's commitment to uphold the rule of law and combat corruption at the highest levels of government. In court of its own motion versus state, the bench of Justice Mridul and Justice Bhambhani passed a series of orders securing the rights of juveniles undergoing trial. In one of these orders, the bench directed termination of all proceedings against juveniles involved in petty offences, where proceedings remained pending for more than 1 year. In another matter, that is court of its own motion regarding Maya Devi versus Union of India, Justice Mridul exercised the parens patriae jurisdiction of the court by acting with alacrity and sensitivity, and consequently directed the medical superintendent, prison headquarters, Tihar Jail, New Delhi, to submit a status report detailing the medical conditions of all prisoners aged 75 and above, and the medical treatment being provided to the ailing persons. In Shivani Bhatt versus State of NCT Delhi, Justice Mridul poignantly observed that every human being has a certain inalienable right, like the right of self-determination. A transgender's sense or experience of gender is integral to their core personality and sense of being. Everyone has a fundamental right to be recognized in their chosen gender under law. The time has come for us to mainstream the transgender community. Upholding the principles of natural justice and fair play to the zenith in context of a detention matter, His Lordship in Zakir Khan versus Union of India held that supplying ineligible relied upon documents is the equivalent of not supplying such documents at all. An order for detention based on such documents could not be sustained as the detainees were prevented from making effective representation in violation of their fundamental right. In Rekha Devi versus State of NCT of Delhi, the court was presented with a heart-wrenching situation wherein a pregnant minor was lodged in a shelter home. An amicus curiae was appointed to assist the court in ensuring that her best interest and health is protected, and for assisting the court to formulate guidelines for the care and protection of minors housed in state-run shelter homes. In Manuel Frederick Baumann versus State of NCT Delhi, the bench headed by His Lordship proceeded to de-seal the report of a child counselor while observing that all custody and guardianship issues are resolved on the touchstone or parameter of best interest of the child. Such issues have to be handled by the court with care and caution, with love, affection, and sentiments, applying a human touch to the problem. In Ruma Bibi versus State of NCT Delhi, the court, while dealing with the challenge to the detention of suspected foreigners at detention camps, took note of the poor upkeep of the detention center and directed the state to take immediate remedial steps to address the below par living conditions in the center. His Lordship always has and will continue to teach us the balance between following the letter of the law and the endeavor to grant justice to one and all despite any circumstance. We thank your Lordship for teaching us the intricacies and celerity of the profession and for being present here today to launch the first discourse. His Lordship will speak on the presumption of innocence, the nuances, and the conundrum.
Thank you, Shreya. Coupled with what my learned brother had to say earlier, it sounded almost like a farewell speech. Good evening to all my friends, colleagues, ladies and gentlemen. I reversed the order not because I wanted to have the last word, but I wanted to be a bit of I wanted to summarize the proceedings of the evening, as well as to report on what had been achieved. I will start at the beginning by congratulating the Center for Discourses on Criminal and Constitutional Jurisprudence on this wonderful adventure which has already achieved more this evening than most organizations have in their entire period of existence. Not only have we heard discourses that have been weighty and presented in inimitable fashion by Dr. Arun Mohan, my friend, old friend Hari Aran, and Justice Anup Bhambhani, who has held my hand on the bench during difficult matters and otherwise. Well, I'm speaking on the subject that has always been closest to my heart. In fact, it's the reason I became a lawyer, human rights. And when Harsh first approached me with this, with the idea of addressing and organizing a seminar, and he asked me the follow-up question on what it should be about, I said human rights, what else? Now, the reason I say that is because I believe that personal liberty is the paramount essential, the sine qua non for human dignity and human happiness. To quote John F. Kennedy Jr., he said the rights of every man are diminished when the rights of one man are threatened. Well, as Shreya pointed out, I majored in history before I studied law, and I always look at the historical perspective before I address any issue. And I truly believe in the adage that those who forget history are condemned to repeat it. So I will begin with the historical context. And I must tell you that personal liberty is how you define civilization. Because without personal liberty, you can have nothing. You may have resources, you may have the infrastructural setup, you may have artificial intelligence, but unless you have personal liberty, most of it does not amount to much. And I would, when it comes to human rights, I would also like to quote from Bob Dylan, the Nobel laureate, who said that how many roads must a man walk down before you can call him a man? The answer, my friend, is blowing in the wind. The answer is blowing in the wind. Well, it's not personal and individual liberty is not a recent concept. It is steeped in history. It began if we were to go back in time and if you were to look at the Ashokan Rock Edict number 12, which goes back to almost 2,500 years, it says that where it is, so to speak, written in stone, cast in stone, that a severe king meting out unjust punishment is hated by the people he terrorizes. And this coming from somebody as gifted as Ashoka the Great, as accomplished as Ashoka the Great, truly indicates how that it was intended for posterity. Well, let me also dwell a little on the backdrop in which individual human rights came about and how they evolved. One must remember that throughout history, there's been a struggle between subjects and kings. And over time, that struggle has today metamorphosed into the struggle between citizens and the executive. And in a thriving democracy, the protection of individual liberty is a fundamental duty. Therefore, as we see, liberty and welfare of the people is a concept that has been around ever since humans became civilized. And as we are all aware, today it's an accepted doctrine that all human beings are born with equal and inalienable rights and fundamental freedoms which are absolute. Therefore, the rights of men have been a concern for all of civilization from time immemorial. The protection of individual liberty has also been considered to be one of the fundamental duties of the state in many civilizations. The emergence of constitutional guarantee as a device to protect individual liberty against the state is certainly more modern. The very idea of a guarantee of liberty suggests existence of some power above the ordinary law of the land to ensure liberty as a special privilege. It is the protection of liberty by the Constitution as against legislative action that constitutes the essence of a constitutional guarantee. Fittingly, I would like to revisit an excerpt from John Stuart Mill, and to quote, he said, "Cyrus the Great was a ruler who ruled from the Indus Valley all the way into Europe, and he is best known as a liberator of the Jews who had been incarcerated in Babylon. Today he is remembered for the discovery of a Cyrus cylinder made of baked clay, on which is inscribed the duties of the king and the rights of the subjects. Even though the rights are quite basic and not evolved as the rights in a democracy, it's a starting point. All that it indicates and shows is that even 3,000 years ago, there were enlightened beings concerned with rights individual. In addition, we had the Hammurabi's Code. Of course, all of this came to a head in the West with the Magna Carta. I think all of us are familiar with that, 15 June 1215. Now, the principle in force prior to the Magna Carta, which gave rise to the dispute between the king and the citizenry, was the principle that was called vis et voluntas, which was the principle of force, that the king by force imposed his will on the people. And I think Justice Bhambhani alluded to that in his speech, and I think so did Mr. Hariharan. Now, what had to change was that the citizens demanded more rights. They demanded personal freedom, they demanded fair trial, they demanded procedural safeguards, and the Magna Carta, the Charter, as it is called, was the first in Europe to clearly delineate the rights of men. And one of the first occasions that the king agreed to fair trial, and the king agreed to the presumption of innocence for certain categories of detainees. Well, of course, William Blackstone, the English judge, the famous English judge, numbered the clauses in the Magna Carta into 63 categories in 1759. These numbered clauses greatly influenced the early American colonists and led to the formulation of the Constitution of the United States and the Bill of Rights. In the Bill of Rights, the most prominent is the right to personal liberty and the security of the individual. Ergo, speedy trial, right to know the cause and nature of the accusation by an accused, right to cross-examine and to obtain witnesses, right to have legal assistance. That included the right to bail and the remedy against unreasonable denial or refusal of bail. Well, the term liberty alluded to in the Magna Carta was made synonymous with individual liberty for the first time by Chief Justice Coke in the United States. And he coined the expression individual liberty, quoting from the Magna Carta. It has now, of course, become a deeply enshrined part of our constitutional safeguards, and in fact is today a part of the basic structure of the Constitution. Article 21, and I think it was Mr. Hariharan who spoke about it, and who also spoke about Article 20 in passing, I believe, when he referred to being convicted for an offense, which is an offense at the time it is alleged to have been committed, and to be convicted for a sentence that the law provides for at the time when the offense is alleged to have been committed. Now, Article 21 has been expanded and enlarged by the courts in India in its application. Before I move on to the presumption of innocence, which is a well-defined safeguard when it comes to the rights of an accused, I must invite attention to Justice V.R. Krishnaya's celebrated judgment in State of Rajasthan versus Balchan, if I am not mistaken, where I think he very famously said something which is misquoted by criminal lawyers, defense counsel every day before us, bail and not jail. And what he actually said was that the basic rule may perhaps be tersely put as bail, not jail. Well, let's move on to the subject I've been asked to address today. And I've had a long wait, honestly. Long and enjoyable wait. Of course, I would have come a long distance to see Dr. Arun Mohan perform as he has been for the last 40 odd years or 50 odd years, is it, Dr. Mohan? And I remember once attempting to brief him in a matter which was to come up in the following month, to be told that next month I haven't time till the next 5 years. Mercifully for me, I argued that matter, and so began my journey as a counsel. Well, see, the expression is I incumbit probatio qui dicit, non qui negat, which means that there is a presumption of innocence for every person until he/she is proven guilty. Right? Now, the origin of this expression is found in the Digest of Justinian, rendered as early as the 6th century, containing the maxim which gave rise to the doctrine, the principle of presumption of innocence. Of course, subsequently, Emperor Antonius Pius introduced it into the Roman criminal law system. Today, it's a part of legal systems around the world, and it has been evidently accorded much significance. Well, at the outset, to summarize, the principle which applies both at the stage of a trial and at the initial stage of bail clearly states that a person is presumed to be innocent unless he is proven guilty. Now, it finds resonance in Article 11 of the Universal Declaration of Human Rights, which mentions it as an international human right. The presumption of innocence, the principle, I make bold to say, is the very elixir of the criminal justice system. It is evidently today a recognized legal right. I would go so far as to say that in India it is a fundamental right. In the earlier days, it was considered by the Honorable Supreme Court to be a human right, but subsequent decisions, including the one cited by my brother, the Sahara case, it has now been treated as a fundamental right. That leads me to the next part of my presentation. Unlike Justice Bhambhani, I am not tech savvy, not even artificially intelligent. Although artificial intelligence to me sounds very, what should I say, it evokes memories of what the gentleman who participated in the manufacture of the nuclear bomb said. He said, "I have become death." Robert Oppenheimer. It sounds very Oppenheimer-esque, because he very famously said, and he quoted from the Bhagavad Gita to say that I have become death, the destroyer of worlds. Yeah. That's what artificial intelligence reminds me of. Besides, of course, it's very Orwellian, 1984-esque. Well, we who man the criminal jurisdiction are familiar with a lot of things that we could classify as Orwellian, but we'll keep that for some other day, that discussion for some other day. Well, the expression presumption of innocence was first used by the British barrister, Sir William Garrow. He coined the phrase presumed innocent until proven guilty. He was of the view that the accuser should be tested robustly in a court of law, and the juror or judge must conclude beyond reasonable doubt that the accused certainly did not commit the offense. Later on, in Wilmington versus Director of Public Prosecutions, referred to by Dr. Arun Mohan, the English Court of Appeal held the phrase to be the golden thread running across the web of English criminal law. If observed from a general point of view, most people accused of certain offences are not criminals. This was reflected in the phrase of the French jurist Jean Lemoyne when he said that item quilbe presumpta innocence nisi probita nocens, which loosely translates to state that a person should be presumed innocent until his/her guilt is proven. It goes one step ahead to state that the accused defendant should be given certain protections, prior notice of the accusations made against him, and should have the right to counsel of his choice. In India today, as in a number of jurisdictions across the world, the right of an accused to be presumed as innocent is a fundamental right. Apart from the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, under Article 14, states the principle of presumed innocence. Article 66 of the Rome Statute of the International Criminal Court expressly mentions the presumption of innocence principle. The European Union, the Inter-American Court, and countries like Canada, France, Russia, and New Zealand also abide by the principle. This harks back to William Blackstone, who very famously said that it is better if 10 guilty escape rather than 1 innocent suffer. The presumption of innocence principle seeped into India and was adapted because we followed the English common law system and with British colonialism. In India, although the expression is not mentioned in as many words anywhere, it can be said that the rule is deeply embedded in the criminal jurisprudence of our country. It can be inferred from the mandate of Article 20, Sub-Article 3 of the Constitution, which states that no person can be compelled to be a witness against himself. Full stop. It is the right against self-incrimination, which, if not granted, would place the burden on the accused instead of the prosecution. In Dataram versus State of Uttar Pradesh, the Supreme Court held that a postulate of criminal jurisprudence is the principle of presumption of innocence. Now, before I go further, I must invite your attention to the case law on the presumption of innocence and how it has evolved in India over the years. In 1980, the Constitution Bench in Gurbaksh Sibiya's case hailed the presumption as salutary and deeply grained in our criminal jurisprudence, but stopped short of saying that it flows from Article 21. Nonetheless, the court held that while interpreting Section 438 CRPC, which provides for grant of anticipatory bail, a liberal approach must be adopted in view of the presumption of innocence. For the right, and I quote, for the right to personal freedom cannot be made to depend on compliance with unreasonable restrictions. A holistic reading of Sibiya suggests that the court implicitly recognizes a link between Article 21 and the presumption of innocence, though it is not precisely spelled out. In Narendra, in 2004, a division bench of the High Court labeled the presumption a human right. Thereafter, in a 3-judge bench of the Honorable Supreme Court in Ranjit Sharma, referred to it again as a human right. Some subsequent Supreme Court judgments appear to diverge. In Noor Agha, where the court was considering the provisions of NDPS, which reversed the presumption of innocence, the court held that the presumption may be a human right, but cannot be equated with the fundamental right and liberty adumbrated in Article 21. Closely upon the heels of Noor Agha, the court in Vinod Solanki and other cases found it well settled that the presumption of innocence is only a human right and not a fundamental right. But today, in 3 judgments of the Honorable Supreme Court, one by a Constitution bench and 2 by 2-judge benches each, it has been held that the presumption of innocence is a fundamental right. The first of them being Manu Sharma. In that case, the court was considering the impact that media trial can have on the right of the accused to a fair trial. Stating that media trial can potentially destroy the presumption of innocence, the court held that such a scenario would be opposed to the very basic rule of law and would impinge upon the protection granted to an accused under Article 21. Second, carrying this view forward, the Constitution bench in Zahara versus Sebi, and you've read excerpts from that judgment, explicitly held that the presumption of innocence is embedded in Part 3 of the Constitution, not only as a part of rule of law under Article 14, but also as an Article 21 right. And hence the freedom of speech under Article 19(1)(a) can be restricted under a balancing exercise to protect the presumption from the dangers posed by a media trial. Now, Article 21 and the link is that Article 21 permits the state to breach the right to life and personal liberty by incarcerating a convict only following a fair, just and reasonable legal procedure. Keeping the judgments aside, the link between Article 21 and the presumption can be traced directly to the just, fair and reasonable requirement of the law. There are at least two reasons why I believe the presumption of innocence is an important aspect of fairness and reasonableness in criminal law. The first reason is compliance with Article 14 and the decision of the Supreme Court in Maneka Gandhi. In Maneka Gandhi, a law restricting personal liberty was required by the Supreme Court to pass muster under Article 14. Hence, if the law makes a classification between somebody charged with an offense where he is entitled to presumption of innocence and special laws where he is not so entitled, in some of them, including NDPS, FOTA, that come to mind. I'll hold back on the others. If the law makes a classification, it must be shown that the classification has a rational nexus with the object sought to be achieved. Article 14 prohibits an unreasonable classification made by a combination of laws. Hence, if two offenders are treated differently from the perspective of the presumption of innocence by two different statutes, the test of Article 14 would not be satisfied. Of course, in Maneka Gandhi, the Supreme Court very famously observed that the object of criminal law is to secure convictions of the guilty and acquittals of the innocent. It is true that the relative importance of these two goals is different under the two models of criminal law. The crime control model or special laws focuses more on securing punishment for the guilty and endorses the possibility of mistakenly convicting innocent persons on a few occasions. Protections for the accused are lowered possibly under that model. In contrast, the due process model places more emphasis on strengthening protections for the accused, even if that means let 100 guilty men go scot-free. Despite these differences, however, both models follow the common aim of punishing the guilty and sparing the innocent. Neither model aims to punish the innocent and neither aims to spare the guilty. To be meaningful, even if the crime control model must avoid wrongful convictions, for every wrongful conviction means that the actual offender remains scot-free, which fact is unknown to the state. As regards bail, which is the other part of presumption of innocence, The state certainly has a bigger interest in preventing the more heinous offences from being repeated by the accused. However, that interest can be achieved equally effectively under the traditional rules governing grant of bail, which required a court to inter alia consider the gravity of the offence, evaluate the prima facie case against the accused, and judge his antecedents. In fact, if anything, the heinousness of the offence should imply heightened, not lowered, protection for the rights of the accused. As the Constitutional Court of South Africa notes in Kwetsi, there is a paradox at the heart of all criminal procedure, in that the more serious the crime and the greater the public interest in securing convictions of the guilty, the more important do constitutional protections of the accused become. The starting point of any balancing inquiry where constitutional rights are concerned must be that public interest in ensuring that innocent people are not convicted and subjected to ignominy and heavy sentences massively outweighs the public interest in ensuring that a particular criminal is brought to book.
How we wish. That's a criminal lawyer's wish.
Well, I'll just conclude very briefly. Every accused, regardless of the offence he is charged with, is entitled to the presumption of innocence as a basic requirement of fairness under Article 21, read in conjunction with Article 14, right? But as Hari reminded me of this famous couplet by Ghalib, which is every defense counsel's refrain, says, "Ya Rab, na wo samjhe hain, na wo samjhenge meri baat. Ya Rab, na wo samjhe hain, na samjhenge meri baat. दे और दिल उनको जो ना दे मुझको ज़बां और." Well, I'll just briefly encapsulate. I dealt with the origins of the principle of presumption of innocence, going back to Justinian. I dealt with the essence, and I've also dealt with the scope of the principle. Of course, this is an ongoing debate, and I'm sure it will continue. I must express my gratitude to all of you for having taken the evening off, if you have. Yes, it's 8:30, to be here to not just encourage the speakers, but to encourage the center for having begun this wonderful initiative. And I'm certain that even if the center is unable to dispel the presumption of innocence of the law, when it comes to lawyers, it will help the judges in formulating weighty discussions on subjects related to human rights, including the presumption of innocence. Thank you very much, all of you. It's been a wonderful evening. Jai Hind.
We thank His Lordship for enlightening us. As a part of our vote of thanks, we are also grateful to Mr. C.K. Chaturvedi, Presiding Officer, Special Court Saket, Mr. Raj Birbal, Senior Advocate, Mr. B.B. Gupta, Senior Advocate, Mr. Pramod Kumar Dubey, Senior Advocate, Mr. Sanjeev Rali, Senior Advocate, Mr. Vivek Sood, Senior Advocate, Mr. K.C. Mittal, Member Bar Council of Delhi, Ms. Anjana Prabhakar, Member Bar Council of Delhi, for gracing this occasion. We wish to thank everyone for taking the time to be here with us at our inaugural session. We hope for your continued blessings, support, and encouragement. I now request all the committee members to come on stage to take a photo with the speakers. Thank you.
बैठना ही पड़ेगा।
Thank you very much. It would not have been possible if one of these days I have to make a PowerPoint presentation. Not that. That's all. Thank you. Thank you so much. Dr. Sir, thank you so much for being here. Yeah, simply explain. Yeah.
Not for this time.